It's Lisa from Been There, Got Out. And I'm going live with Sean Valentine, who's the family law coach from Canada. Here he is.
Hello.
Hi.
How's
Oh,
it going?
oh, there you are. Okay. So, I was saying in, I think this morning's post is like Canadian theme this week. And you've had some very significant cases.
Yeah,
So,
we can
Sean,
break the
before you even
flag
get
on
into it, you
Canada.
want to introduce yourself again?
For sure. For anybody who doesn't know me, I'm Sean Valentine from the Family Law Coach. We operate in Ontario, Canada, and we provide self-represented litigants, or in the US, they're called pro se litigants, with coaching services in their family law matters. And the idea is to empower people because we know that the struggle is real and the fight is an uphill battle against the court and against your opposing spouse. So we're here to offer some legal insights to help individuals succeed in the courts.
That's great because I again have court tomorrow and I'm not even going to turn the camera on the pile of papers in front of me. And, I'm pro se. So I know we're not going to talk about that today, but I thought still just channel me some good vibes to hopefully finish off this part of the case.
I'm
It's going
setting
well
music.
so far.
I can't believe you're doing this IG live the day before you got to go to court. That's
I,
real impressive.
I know. And then we actually have a meeting with an attorney at 7. I'm,
All right.
yes.
Listen,
But
you're
let's
doing
get
this
to
for the
it.
greater good, the better for everybody, right?
Yep. Okay, so Sean, because I've been so busy preparing for court, and I know that you and me and David Morneau, who's your colleague, and Chris had a meeting the other week and talked about some ideas for future Instagram lives, and we came up with 2 or 3, I'm thinking. But and I know we talked about talking about one case in particular that recently happened in Canada, but I'm thinking maybe we can talk about those two biggies.
Oh, the 2 biggies. Do we have time for that with your meeting at
Yeah,
7?
yeah.
So I think the first one we should definitely talk about is the tort of family violence that really came out of there, and it was incredibly impressive. And then maybe you can lead in the second one, and then we can kind of go from there. But the idea was that similar to some of the states have been recognizing tort law as associated with battered women syndrome and recognizing that there should be some damages flowing to an individual who unfortunately suffers these horrendous situations throughout their relationships. A court in Ontario, the Superior Court of Justice, made a decision very recently, actually, that has created this new form of tort. And what the term tort just means is that it's a harm to somebody else civilly. So that if someone does something bad, you think of it more from a car accident perspective, that if someone gets hit by a car, the tort is called as negligence, and there's a duty there, and basically someone can be compensated monetarily for those damages. And so what the judge made a decision here was that, looking at all the evidence, and I might add, the successful party was actually self-represented in this, yeah, which is very impressive. And so the wife put together pretty much a pattern of coercion and control over a 16-year marriage. And the judge looked at this and said, the way the legislation is put together doesn't actually compensate someone for this appropriately, because when we look at spousal support, we actually can't look at family violence. We actually can't look at coercive control when we're awarding this. It's really designed to compensate someone for self-sufficiency, or requests to get someone to become more self-sufficient from a monetary perspective, from a compensatory perspective. Now, this is more recognizing that there are actual damages arising from conduct throughout the relationship. And what the judge went through a very lengthy decision. And I think what I'll do is I'll send you the link to the case afterwards, and you can highlight it and post it for people, because it's a really interesting read. It is a little lengthy, but the judge actually separated the damages into about 50,000 for compensatory damages, awarding for to assist the wife with going to maybe some therapy or some counseling or things that they recognized that there was going to be some medical bills stemming from this. But then the other 100,000 was really about aggravated and punitive damages, recognizing that what the person did, what the husband did through this relationship, was so coercive and so abusive from a physical and an emotional perspective that the judge recognized that there's no way to not compensate this person for it. And that's really was the undertones of the decision was making a decision here that to recognize that other states and other countries are starting to come up with this idea and recognize that someone should be compensated for these reactions in these situations that occur. And the judge realized that this was novel and recognized that there might be some dissent, there might be some people that might look at this as being a slippery slope, but based on the evidence of this specific case, the judge really felt that it was necessary to compensate the wife for the history of control, coercion, physical abuse, emotional abuse.
Wow. Okay. So now a couple of things. So she was pro se, and I know we've talked before, and I saw your post, I think it was today, that said common mistakes that pro se litigants often make is we tend to be very emotional because it's about our lives. So here you're saying there's a woman who was in at least a 15, 16-year marriage who was able to get herself together, present her case so well that now she's getting all of this money, and not just for physical abuse, but how is she able, do you know how she was able to put together such a strong case to win something like this?
So what was even more fascinating was an 11-day trial. This was not just about the damages. There was still property that had to be dealt with, and child support and spousal support and valuing the business. But from what I can read, and I'm only reading through the tea leaves of what the decision says, but she was obviously very informed. She was an educated individual. She really picked and dealt with the right type of evidence to ensure that the actual consistency and credibility of her evidence was being presented. She brought back two witnesses that could verify the accounts or some testimony that she told. A friend and another friend that lived in Edmonton when they were living in Edmonton as well, about some of the situations that were happening as early as 2012 and 2013. And so she was really hard focusing on the importance of verifying and making her evidence credible. And really the unfortunate part was that the father, who was actually represented in this, ended up not being as credible, because he was doing what we always tell people not to do, trying to attack the individual and saying that she was incredible, that it was only in hindsight that she was, calling the police now to try to verify it because she was in court trying to establish these damages, and really just trying to make the wife look bad, opposed to just trying to highlight that, maybe try to minimize it and not try to negate the whole concept, but try to minimize the potential damages that were going to be awarded down the road. And then on top of that was what was more interesting, because this is kind of what we call a novel new tort, a new part of the law that's being crafted here. The judge actually had to ask for submissions at the end of the trial, by written submissions, on why we should be even considering this. Why should the judge make a ruling about something brand spanking new that in Ontario has never been recognized before? And so the pro se litigant, the wife, actually had to write written submissions about this, and really kind of had to touch upon the area of jurisdiction and legislation, and making sure that the judge understood her position. And now I think there might have been some leniency, because obviously she was self-represented, and I think that I'm not saying that the judge got into advocacy, but I do think that the judge definitely saw the arguments that were underlying her submissions and was able to craft something that was going to be advantageous and beneficial to the actual facts of the case.
Yeah, now I'm thinking a couple of things. So she had two witnesses, and these weren't even expert witnesses. These were not specialists in domestic violence who were brought in to prove anything. These were friends of hers that could just verify what had happened, starting from a decade ago at least.
Yep. And then what she also did was she basically requested all the documents from her treating physicians. So not expert physicians, but what we call participant experts in Ontario. I'm not entirely sure what they're called there, but they were just requested the documents to corroborate the stories. So the whole idea was just, again, to say, I went to my GP in 2013. I mentioned this to him or her, and then I also saw a counselor in 2015, and I messaged, and just to leave that trail of breadcrumbs to show that it wasn't just something out of hindsight that was being created now and with more, reflectiveness on this because there's the trial here. She wanted to show that it was contemporaneous. Those things were happening as the witnesses or the people were corroborating those stories.
Yeah. And what's fascinating is too that what mattered most was her credibility. So however she did it, she was able to appear the reasonable, believable one against obviously an abusive person. And often the abusive ones are the ones who are very polished and get away with a lot in court. So
Absolutely.
that's amazing. And the other thing is, so now I know in our states we say that it's now case law or legal precedent. Is that what you call it in Canada too? So she's now established legal precedent. Now, is it just for that limited part of Canada, this jurisdiction, or is it all of Canada?
So the way it works here is that there are different tiers of family law jurisdictions and different courts that you can go to specifically in Ontario and then specifically in different provinces. That this case would be at the Superior Court of Justice, which usually deals with all property issues and deals with other things like spousal support and child support. It would be influential. So there would to a subsequent decision by a similar judge. So the Superior Court of Justice would look at this and say, I'm not bound to follow this, but this is something that has been treated like this going forward. And I think this is something we talked about before, I would probably go and appeal this if I was the father. I would probably go and say, okay, we got to take this to the Ontario Court of Appeal to see if what the treatment could be about this. If the Court of Appeal adopts this ruling and says, I agree with this, and this new tort has been established, that becomes now precedent for all of Ontario and will be very heavily relied upon in other provinces because Ontario is usually seen, along with BC, as kind of being the bigger provinces when it comes to judicial authority, similar to like a New York or a bigger state in that sense where there's a lot more litigation that happens. So if we can get it to the Court of Appeal, it gets appealed and it gets dismissed, then this authority will be pretty have a lot of weight for the whole country.
Wow. I mean, this is so exciting. Now, how was she able to take it to civil court? Because I know in the past when I've investigated different avenues of possible penalty, I'll just say, everything got said, oh, no, this is a family court matter. So how is she able to move something like this into a civil court?
So what's interesting is she actually did amend her answer in family court to include this specific claim. And so what happened was when they went to a trial management conference or settlement conference before the actual trial was going to be scheduled, the judge at that settlement conference recognized that there were two kind of parallel concepts or two issues that might be residing here between the family issues and the civil issues. And so he actually made it, I'm presuming it's a he, the judge at the trial conference made an order saying that those two would be tried together in the family context. And there actually is information in this decision that's highlighting that they want to try to do that going forward. They want to acknowledge that this shouldn't just be brought in a civil arena. It should be brought contemporaneously in the family courts because we want access to justice. We want the ability for people to make these claims and not have to have these duplicate proceedings, which are going to be costly, time consuming, all the different things that can factor into it. And so the judge did mention that it should probably be brought at the same time within the family system. But I do say, and I think we talked about this before, there is the possibility of some exploitation like this where people could be commencing different proceedings. They could be kind of exhausting the court system with one lawyer dealing just with the tort damages and then the other family law dealing with the other stuff. So it's going to be interesting to see how this kind of gets treated going forward like that, but it's still a really fascinating decision that I think is going to have a lot of weight going forward in terms of recognizing that there should be compensation for these types of actions and people shouldn't just be scot-free after doing unfortunate things to their spouses during their relationships.
Yeah. Wow. I mean, it's amazing. Okay. One last thing on this case. So the judge, you kept saying the judge really got it. Like, why do you think this judge got it? Do you think this judge was educated or she just got lucky? Is there training for judges in Canada? Everyone here is complaining that judges aren't trained enough.
There's definitely training. I think we've spoken about this before too, that a lot of people, a lot of judges and lawyers, excuse me, that go through and practice family law or mediate family law, they do go through domestic violence training and power imbalance training, and they do recognize that this is happening. What happened and what was timely was that the mother actually made this as a claim and amended her answer to include this specific tort. So had she not included the damages, and I don't even know if she really knew necessarily what she was doing, but I think she just might have added it to say, like, I want aggravated damages or compensatory damages for family violence. That opened the door for the judge to consider it because it was in the actual answer. It becomes a claim and it has to be considered by the judge, or there's grounds for appeal because it wasn't actually thought about. So it was very great on the wife's part to actually bring this forward so it could be considered during the trial. But I think obviously it took some time probably for them to actually get submissions on this because it is so novel, and the judge has to do their part in making sure that every claim is discussed and analyzed and resolved at a trial, because then again, like what I was saying was that it opens it up for appeal, even a much easier appeal if they haven't actually dealt with a certain claim.
Yeah. Wow. Well, that is amazing. I know we're all excited about it. Just seeing the headlines, like, that's
Yeah,
great.
yeah,
That's great.
it's awesome.
Are you happy about it? I mean, you said that there might be some exploitation, but do you think this is a move in a good direction, or what do you think?
I think it's a great idea in the sense that it's recognizing that there are power imbalances, there are significant issues that won't be compensated and won't be recognized by law outside of the relationship. And a lot of the people that we speak to, the hardest thing is, to move on from is that control or is that type of abuse that they might have. And I'm not saying that this is going to compensate them fairly for it, but it's going to recognize and potentially validate, and it'll give people opportunities um, to have their voice heard about this specific thing, and then also be recognized in law versus just saying, I recognize that there was coercion or abuse or different things like that. I am concerned a little bit in the sense that it could open some floodgates and it could create a lot more litigation, and really the concept of family law in Ontario and Canada, we are trying to move away from courts. We are trying to become much more ADR focused in mediation and different things like that. And this might be a barrier to that. It could create now saying, I'm not going to negotiate or I'm not going to accept some type of resolution unless you recognize X dollars for the different types of family violence that occurred during the relationship. And so this might just be another layer now that lawyers or pro se litigants are going to have to negotiate and come to some type of an agreement if the facts fit this mold, and people are looking for those types of damages.
Yeah. I can imagine the threats
Yeah,
that go on.
yeah,
Like, I'm going to get you for this much money. Everything
yeah.
you've done, you're going to pay for.
And that's the problem, right? And especially where there's now case law establishing a threshold amount that might be able to be paid for. And don't forget, the tort law is the thought process behind it is it's supposed to be, you're compensating for actual damages. It's not just theoretical, and it's supposed to put the plaintiff to return them to whole. So what they've lost is trying to get them to get net even. So we're not going to be looking at, potentially, hopefully not $1 million settlements and stuff, but there is some arbitrariness to this, and there is some theory about how we can monetize aggravated damages and punitive damages if they're going to be awarded. And so you're right that it might be a little bit more difficult to quantify that. And then there could be a very large spectrum of what someone thinks the quote unquote family violence is actually worth monetarily in a settlement.
Yeah, and I'm also thinking in terms of how to show coercive control and then how to show a price for that. So I think it's really neat how you said that this woman got awarded damages to pay for therapy. And I'm wondering, how is she able to present that? Physical, you can see the bruises, somebody has to pay a certain hospital bill, whatever. But how do you put a number on therapy, how many years someone's going to need therapy, the type of therapy that they might be able to, that might help them? Because we know these these issues don't just go away.
No, no. And I don't think that, from what I read, it did kind of look like an arbitrary number, but I think the judge recognized and said, I think this is going to be long-standing. And so if this wife is going to have to see a counselor for the next 10 years, let's ballpark it's going to be this amount of money, and they don't have extended healthcare benefits. So we need to factor that in, that it's going to be out of pocket. And so I think that was just an arbitrary designation on that. I don't know if there was really any evidence provided to suggest how much money would counseling be, but that's something to lead. If you have, bills to show that how much the actual therapy costs, and how much, or recommendations from a social worker or somebody that says that this is your plan of care and this is how much it's going to cost in the next 10 years, it's going to be very similar to like, again, to go back to a car accident. When we assess damages for medical benefits or things like that, we usually get expert evidence to highlight that this is what the plan of care is going to be. You'll probably need a social worker. I don't know if you'll need that extent, but it might have to show that I'm going to need 5 to 10 years of therapy once a week, and it's going to cost this much. And that maybe is how they come to the number for the compensatory damages that they were awarded.
Yeah, and I'm thinking also, because I'm a certified domestic violence advocate, that part of what we work on with people is safety planning before they leave the relationship. We always say, get as much evidence as you can together, and we focus a lot on, the financial documents and the passports and birth certificates. But I'm thinking, just talking to you now, that maybe people should start thinking about keeping receipts of how much they've had to spend on therapy. Just to say, this is what's cost me already. And to think about doing that, during the divorce process as well.
Yeah, that's an interesting way to think about it. You're right. We do usually have clients, we see that they talk about how much money X, Y, and Z is cost, and usually we're only concerned about the expenses associated with the children, and we're trying to think about it, how we compensate for those expenses at that point. But now, you're right, you might be able to have to keep a running tab of what your therapy is cost, or what different things it costs in terms of counseling or speaking to you, even like that could be compensated. You might need someone to continue it, right?
Yeah, well, we actually have clients that are able to apply this to something other than a personal expense.
There you go. There you go.
Yeah, it's great. Wouldn't it be wonderful if insurance started covering it?
Well, that was
legal fees and,
that's
and divorce coaching.
But divorce coaching should be factored into extended healthcare benefits. I think it's important from a mental health perspective that somebody definitely is there and helping you through the process, because it's, as you know, some of the most emotional highs and lows you'll have in your life.
Tell me about it. Yeah. Okay. So Sean, I'm thinking, let me just look at the time. Maybe we should wait on discussing that other big case.
Sure.
Let's wait, because I think David's going to want to say a few things about it. Yeah. So maybe we'll just talk about this one for today, and then we'll save it. And I think we have it on the calendar for sometime in April.
Yeah, I think we're in April, and I think that's a good idea, because I know David's going to want to get in on that, and I think he'll offer a nice fresh perspective on
right. We don't want to steal his thunder.
No, never. I would hate to do that. I do think that this case, I think I could spend hours talking about it, because it is really fascinating. I do encourage people to read it, because it does offer up some information on how they got to this, and how they've determined where in the legislation we're going to get the definition of what the tort is, how we are going to figure out the legal duty of a husband or a wife or a spouse, and how that person has breached that duty. And that's the whole concept of tort law, is that the judge basically recognized that there's a duty here on spouses to behave correctly and behave adequately. And then by having the family violence occur, that is the breach of the legal duty there. And then on top of that, the reason that the aggravated and the punitive.
Uh-oh. Oh, wait, Sean, I don't know if it's me. I think your volume went off. Say something again. Can't hear you. I don't know if anyone who's listening now I can hear you. Okay, say it again.
Yeah, I had a call come in. Sorry about that. All I was saying was that it's a really fascinating case that you should read, because it'll highlight how that duty gets, and what the judge has highlighted too is to get to those punitive and aggravated damages. it's more than just a legal duty. It becomes more of a fiduciary duty, which means it's almost like an investment banker or broker to you, or a lawyer to, someone holding a lot of value there. And the idea was that the coercion and the control really elevated this to the aggravation and the punitive damages, not so much just from the compensatory side of things. That type of coercion control was kind of the reason why those got awarded, because they recognize that is next level. That is a really, you've broken this fiduciary duty to your spouse, and there needs to be a recognition of that.
Yeah, and as you're talking again, I'm thinking almost like a marriage contract, that maybe part of this will make the contract more respected. If it's concluded that as part of the contract that you have to be respectful, that you can't abuse the other person. So it is really fascinating.
Yeah, it's really interesting, and I think it's a timely response from the court, in the sense of what we talked about before too, is that in Canada, family violence is now getting put into the legislation. There's a recognition that this is imperative and it's important to the assessment of a separation and divorce, different things like that. And so I think that dovetailed very strongly from the amendments that the legislators have put together at that time. And so it really, and I know that some states are doing the same thing, and they're starting to recognize that as well. And what we said from the very beginning, that there are states that now could look to potentially this specific case, and you could use this as being persuasive. A pro se litigant in New York could now say, look, in Ontario, they've established this, and they've recognized that there is this tort. I think that this should be something similar. We should recognize it here. And so it's got a lot of weight for all of the common law states and all the common law provinces and countries. And I think it could be interesting. We will have to wait and see, though, if it gets upheld, if it goes on appeal, which could happen in the next month or two. We can see what happens, but it probably won't get discussed till later on in the year.
Yeah. Well, thank you so much for talking about it, because I know when I just posted the picture of the headline of the article last night, we got a lot of people excited.
Yeah, I'm really happy to share it with you. Like I said, it's a really fascinating read, and I'll send you the link if you want to post it in the story or wherever you want to put it. And people can go and maybe spend a half an hour reading through it. It's really interesting.
Yeah, definitely. Whether you're pro se or not, just bring it to your lawyer's attention. If you think it might have anything to do with your case, why not just see?
Absolutely. I agree completely.
Yeah. All right, Sean. So I will catch up with you in a month with David, and we'll talk about the next case and a few other things, of course.
Of course. And I'm going to set aside a couple hours for that one.
I know. All right. Take care. I'll talk to you soon.
All right. Good luck tomorrow.
Thank you. Bye.
Bye.